critical to the meaning of civil liberty. And so what we're doing now is trying to go through some of the amendments in the Bill of Rights, the first 10 amendments, and talk about their meaning in terms of this conflict between order and liberty. So I want to start today with, and you need not hold my point of view, though I'm going to try to be incredibly persuasive that I'm correct, to show that I'm correct, is the recent Supreme Court decision known as Burwell versus the Hobby Lobby stores. This is a case, still we're talking about the First Amendment, and this is a case about, on its surface, about religious liberty. I wouldn't define it that way, but that's the way it's been defined. So this is a very complicated case. Many of them are. Essentially what happened is, after the passage of the Affordable Care Act, Hobby Lobby stores and another for-profit corporation objected to the requirement that they provide health insurance to their employees, health insurance that would include coverage for contraception. And the belief, the argument that they made was that their objection was on religious grounds. Now, specifically, the decision upheld the Hobby Lobby claims and applies not to all businesses in the United States, but 90% of the businesses in the United States, those that are not public companies, which is to say those that are not traded on the stock exchange and have public ownership. So, the Hobby Lobby folks argued that morning after pills and 2 intrauterine devices were in fact cause abortion, and that they create abortions because they operate after an egg has been fertilized. This is in fact biologically false. It's scientifically false. It's not an abortion, but that's what they held. And they claimed that and the Supreme Court ruled that the Religious Freedom Restoration Act, RFRA, supported their position, and that the court held that however contraceptive devices were provided for under the Affordable Care Act, it needed to be done in a way that burdened the exercise of religion the least. And the court argued that there were less restrictive means for achieving the goal of contraception coverage under the Affordable Care Act. A few days later, they eliminated that alternative, however, but let's leave that aside. What does the Hobby Lobby decision mean? I would argue it's a very dangerous decision, and I'll try to explain why briefly. First of all, it stands for the proposition that employers, which are closely held, meaning they're not publicly traded, if they can prove their sincerely held religious beliefs, they can file for exemption from the contraceptive mandate in the Affordable Care Act. Now, the decision then, in fact, makes it difficult for women employees of Hobby Lobby and another company, and perhaps other private businesses as well as the women and male employee families, to get coverage for contraception because of the quote-unquote religious belief of the owners of the company. But think about that for a minute. So there are Christian scientists that own businesses. Why can't they go to court and say, hey, wait a minute. We have religious beliefs, and our religious beliefs are that we don't go to doctors. We don't seek medical help or the help of medical professionals. We pray. And our belief is that it's a violation of our religion to seek medical services. And therefore, we shouldn't have to insure anybody under the Affordable Care Act. And as I'm sure you're aware, people have all kinds of religious beliefs that are the basis for objection to many, many, many acts of government. And so this opens the door, for example, to people who are pacifists based on their religious conviction. Quakers, for example. Why can't Quakers go to the courts and say, our tradition is pacifism? We're pacifists. We don't believe in spending $750 billion a year on military spending. We shouldn't have to have our tax dollars, and it's a big chunk of our tax dollars, going to fund an Army and Navy and Air Force and all the rest. And this is a slippery slope if there ever was one. Then there are two other pieces that are of this case that are particularly troubling from my point of view. One of which is that the pension funds that the Hobby Lobby has for its employees has at least investments in at least in companies that manufacture and sell various forms of contraception, totaling at least $73 million. So how can you have a religious belief that contraception and various forms of contraception are a form of abortion when A, it's scientifically false, and B, you buy mutual funds that hold items in companies that in fact manufacture and sell those items. So while the Hobby Lobby people successfully argued this is an issue of religious liberty, I think it's not about religious liberty at all. I don't have the right, whether I'm a private, in my judgment, I don't have the right to impose my religious belief, good, bad, or indifferent, on my employees. I don't have the right legally to enforce my religious belief as a professor on my students. And so this is a very troubling decision. It was a 5-4 decision, like many of them are. But it opens the door to all kinds of objections based on one or another variety of religion. I mean, and it could be endless. I mean, another example, there's cases where people have said, well, I work for such and such a company, but my religious belief says I can't work on a particular day. Therefore, even though the company says I ought to work on this day, my religious belief is that I shouldn't have to. So whose rights prevail there? Ultimately, the courts decide. Any comments on this? Well, again, one of the things to keep in mind is I am not making this controversial. Understand that the conflict between order and liberty, as it plays out in American political life and in the political life of other countries, is inherently controversial because it involves conflicts between what governments think they ought to be able to do and what individuals believe they have a right to do regardless of what governments say. So, still with the First Amendment, and this is moving now away from the Establishment Clause. Free speech and free press, no prior restraint. The government can't restrain prior to publication, or at least it's very difficult for the government to do so. It can try to persuade without the use of government officials or agents of force, but and sometimes they succeed, but more often they probably don't. Symbolic speech is protected. A terribly controversial issue. The one that is perhaps most visible is a Texas case during the Vietnam War. There was a protest against the Vietnam War, and one of the protesters burned an American flag. And under Texas law, that was illegal, and he was charged and convicted and sentenced. And he appealed all the way to the Supreme Court, and the Supreme Court said no. Burning the American flag in the context of a public demonstration, peaceful public demonstration, opposing a government policy, is in fact symbolic speech, and it's protected under the First Amendment. In response, year after year after year, the Congress of the United States has tried to pass a constitutional amendment, beginning to pass it, starting the process to pass a constitutional amendment, which requires a 2/3 vote in each house that would amend the Constitution to prohibit flag burning. It has never passed in the House and Senate. And, this is the American flag we're talking about. And it has not been approved by the Congress. That amendment has not been approved by the Congress, though it's come close once. And so this is both an example of how difficult it is for constitutional amendments to be approved, how difficult that process is, but it's also suggestive of the fact that many times and this is really, I think, one of my arguments with the Bardis book. Bardis says, well, what the Supreme Court says is the law of the land. No, it's not, at least in that particular case, yes, but in general, no, because it creates all kinds of other opportunities for people to engage in political action to try to change public policy, and we'll talk more about that either later today or next time. First Amendment protects commercial speech, yet there are permitted restrictions. Those court decisions have found that there can be restrictions on expression, on public assembly, and on petitioning the government, and usually these restrictions are cast under the phrase clear and present danger or immediate threat. So in other words, if a government, a local government or a state government says there are circumstances in which groups, organizations, people in communities, residents are engaged in public expression and petitioning the government in public assembly, but they can, depending on the circumstance, constitute a clear and present danger, a threat to public order, and therefore restrictions on time, place, and manner up to a point have been approved, have been passed by state governments and local governments and supported in federal court decisions. However, they need to be reasonable. Those restrictions need to be reasonable under current understanding of the law, of the Constitution, and we may not always like what transpires. And I'll just give you one case. One of the most visible groups in the country is the Westboro Baptist Church. Has anyone ever heard of them? Well, the Westboro Baptist Church became well known by picketing the funerals of American soldiers who came back from Iraq and Afghanistan dead. And the Westboro Baptist Church demonstrations argued that the reason those soldiers died was because America is morally corrupt, because we are allowing the spread of homosexuality, gay marriage, and so on. Now, this is bizarre thinking from my point of view. The two things have nothing to do with one another so far as I can tell. Nonetheless, there was a case, there was a civil case involving the father of one of the deceased soldiers. That case involved, the father filed a civil suit against the Westboro Baptist Church for causing emotional distress and pain on him and his family because the Westboro Baptist Church was picketing his son's funeral. And the court decision in this case, one of the facts of the case was that at the time of the funeral, the father and the family were not aware of the demonstration. It was only after the funeral, after they had been home, and they saw the demonstration on television. And in fact, the father filed suit against the Westboro Baptist Church, and the father was the rights of the Westboro Baptist Church were upheld. They did nothing wrong, quote unquote, and they did not inflict any emotional damage on the father, and the father had to pay them $100,000 and court costs. Now, this sounds like a horrible injustice in some ways. Westboro Baptist Church has gone to the Supreme Court and had its rights of demonstrating in this manner, and the court upheld their right 8-1. So the bottom line on the Westboro Baptist Church, from my point of view, is really obnoxious. And you can go up, by the way, on YouTube and you can see what their demonstrations are like. These are really, again, my point of view, really obnoxious people. Really obnoxious. And they say ridiculous things. And yet, the most obnoxious, the most ridiculous people in the country, and they're just about at the top of the list, have First Amendment rights. And those rights are not unrestricted. They can, if it's done carefully, their demonstrations can be restricted to time, place, and manner. But if the law prevents their voice from being heard, no matter how stupid and how wrong and how obnoxious that voice is, their rights thus far have been upheld. And so that kind of reflects the long-held observation that the First Amendment freedom of expression protections are not about protecting simply the speech that is politically comfortable, but in fact we don't need that. That speech is protected, but it doesn't need protection. It's commonplace. The speech that needs protection are the things that rarely get heard. Any comments? So some kinds of unprotected speech, defamation of character, libel, obscenity, though obscenity is often like beauty, it's in the eye of the beholder. There have been court decisions that say, well, you know, obscenity isn't the same in New York City as it is in Topeka, Kansas, and there can be community standards that enter into it. Generally speaking, hate speech, that is to say, speech which singles out either usually ethnic minorities, racial minorities, other kinds of minorities, is generally protected speech. One of the perhaps starkest examples of this is the case that went to the Supreme Court. Actually, my daughter worked on this case, of Virginia versus Black. This is a Virginia case in which the state had a law that said cross-burning is an act of intimidation. And this is a case from 2003, and because it's and the facts of the case, very simply, were a couple of white guys burned a cross on the property of a black family, and the court ruled that in this particular case, Supreme Court ruled in this particular case that in order to convict the men of and uphold the law, one would have to show that the cross burning was an act of intimidation, and the court ruled that, in fact, in this case, it wasn't. Pornography is sometimes legal, sometimes not. On the internet, it's generally protected, although libraries can filter internet sites. I think it's important to note that there are all kinds of what some people would argue are obnoxious businesses that operate in our country, and many of them may engage in things that people think are obscene or immoral in some way, but in fact, pornography, as you're probably aware, is a huge business in our country, and generally it is not illegal. Freedom of the press, still with the First Amendment. Libel, defamation of character. If it's in writing, if we're speaking about public figures, one must meet a higher standard to win a libel suit. That is, if I'm a public figure and somebody says, let's say I'm a politician, I'm a congressman, someone says, you're a no good, blankety blank blank blank, you sold out to this, that, or the other thing, that's not libel, it's not defamation, because my job, my place in the society is to deal with all kinds of public issues, and necessarily I'm going to make people mad, different people on different days. So the New York Times v. Sullivan decision says you've got to show malice. In other words, if I'm a public figure and I'm defamed, or if people say bad things about me, I have to show that somebody deliberately published something that was false or acted in reckless disregard of the truth. Otherwise, the courts will hold, I suffered no damage. This is just part of, this is just part of the role I play, the life I live, the work that I do, and people have a right to mouth off about what I do. And one of the more humorous, if risque examples, is the Falwell versus Flint decision in 1988. Do people know who Larry Flint is? You guys know who Larry Flint is?
No.
He's a pornographer. He owns adult bookstores. I think he might own Penthouse, I'm not sure, or magazines like Penthouse, quote-unquote adult magazines. He sells all kinds of adult and pornographic materials. And you know who Jerry Falwell was?
No.
Jerry Falwell was a Baptist minister in Virginia, very nationally, known nationally, He was the head of the quote-unquote moral majority, active in conservative politics, and a very conservative, right-wing, Baptist-based, Southern minister. So Larry Flynt published this ad that appears on the slide, and I'm not going to go into any great detail about it. If you're interested, you can read it. But essentially, it is a humorous and satirical conversation that never took place between Jerry Falwell and an interviewer regarding the first time he had sex. And this is about the last thing I'll say about the substance of the article, or the quote-unquote ad. In the course of the interview, it's clear that he says that the first time he had sex was with his mother. Larry Flynt wrote this. This never occurred. He wrote it to try to make fun of what Larry Flynt regarded was the hypocrisy and probably the stupidity and the repressiveness of Reverend Falwell. And Reverend Falwell said, "Why, you SOB, I'm going to sue you," and took him to court. And he lost. Because it was clear that, among other reasons, because first he was a public figure, and second, it was clear that it was a satirical, it was an attempt to make fun of Reverend Falwell. And the court said, "No, sorry, you're a public figure, and no one really believes this about you, even though it was said about you, even though they put words in your mouth in this fake interview that never existed. But people understand that, and roll with the punches. You got to live with it." So Falwell lost, Flynt won, and by the way, this is parenthetically, this is what can happen when you've got obnoxious people in the society who are in conflict. They end up suing each other. Student expression. Guess what, folks? You have less than us adults. Okay? Your First Amendment rights are much more limited under the law. Does it say that in the First Amendment? It does not. But various Supreme Court and federal court decisions generally support the proposition that the rights of students in public schools, and presumably even more in private schools, are limited. In universities, the universities have a right, at least according to federal court decisions, to have campus speech codes and behavior codes, and to make students conform to them. And those, by the way, some of those behavior codes or codes of conduct even say, here's what a student isn't allowed to do, and if you do it off campus, you're still in violation of the code. There's one important case, especially important case, that I'd like to talk about with respect to students and universities and the First Amendment. And that's the Rosenberger case of 1995. And the reason that case is so important, in my view, is that it brings to light the some of the contradictions that exist within the First Amendment. We like to think, and if we do, we're thinking incorrectly, we like to think that the First Amendment, which, by the way, again, I think is fabulous. I love the First Amendment. I really do. But there are inconsistencies in it, and the Rosenberger case shows how complicated and difficult even the First Amendment, which seems to be clear to everybody, really isn't so clear at all. So here's the case. University of Virginia collects student activity fees at the beginning of the year. Almost all universities do that. They get all the money together, and then the universities, and this particular university said, okay, now student organizations and groups, we want to use these monies to support student organizations and student groups and student activities on campus. After all, it's your money. It's money that you put in and gave to the university for the specific purpose of promoting all kinds of student organizations. So we're going to set up a process by which organized student groups can apply for money, put together a budget, a justification for why you want the money, what kinds of activities you're going to do, and we'll set up organizations to make the determination of who gets how much money to do what. Well, one student group was on campus at the University of Virginia in Charlottesville was a religious group, and that group was an evangelical Christian group that spent much of its time proselytizing other students. You should convert. You should be saved. You should be born again. Holding meetings, activities, etc., all designed to promote evangelical Christianity. And the university said, well, you know what? The Supreme Court has said that we can't endorse, university can't endorse, it's a public university, we can't endorse any particular religious belief. And so we're going to deny you, evangelical Christian student group, we're going to deny you any money. Because if we give you the money, then we are, in a sense, violating the Establishment Clause of the Constitution, which provides that we're neutral on religious matters. We don't endorse any. And the student group said, see you in court, UVA. And it went all the way to the Supreme Court. And the Supreme Court ruled that the religious liberty right of the student group trumped the university's claim that it would be endorsing that a particular religious view or position or tradition if it gave student activity fee money to that group. So student group won. But what it shows is that that there can be a conflict. There, in fact, is a conflict at times between the religious liberty claim on the one hand and the law, the tradition of American jurisprudence that says public bodies can't endorse, practice, inculcate, propagandize, or whatever, one or another, or favor any one or another particular religious group. Any comments on this? Freedom of the press, still going with the First Amendment. The press is the media are an industry, but you can't do anything. One of the more famous cases is that of Judith Miller, who used to write for New York Times and was a so-called expert on foreign policy and especially on weapons of mass destruction, allegedly, prior to the U.S. invasion of Iraq. And she worked with the Office of the Vice President at the time, Dick Cheney. And in the course of her collaboration with that office, she revealed the identity of a woman named Valerie Plame as a CIA agent. And she would not, when it got to court and grand jury, she would not reveal her sources of information, and she ended up being sentenced to 3 months in jail because she wouldn't reveal those sources. So sources can't always be protected if a media organization or journalist is essentially putting American foreign policy and intelligence officials in jeopardy. Another important case regarding free press is the Nebraska Press Association case, where a judge placed limits on gag orders that judges use, so that reporters can publish information about ongoing court cases as long as they're factual. Freedom of the press. The key thing to note here is that the media are regulated by the Federal Communications Commission. The commission regulates the airwaves, it grants licenses, it imposes regulations on broadcasting. If you may or may not know who George Carlin is or was. He was a comedian, very controversial at times, usually very, very funny in my view. And he did a piece many years ago on the 7 words you can't say on TV. Except now you can say most of them, maybe all of them. One final case, it's not a court case, but it was a public issue in the mid-1980s. So this is before you were born. I'm sure that you probably, I'm not sure, but I imagine you hadn't heard of this. There was a group called the Parents Music Resource Center, and the wife of the Secretary of State at the time, Susan Baker, and the wife of Al Gore, Tipper Gore, were involved in lobbying Congress. They were sure that all kinds of bad messages were on records, and that records needed to be labeled like movies, so that people your age would not be subjected to all kinds of awful things, music that promotes suicide, rape, sadomasochism, and various other kinds of activities that they objected to. And so they were arguing for a law that would require, or a process that would require, placing warning labels on music products. I think they didn't succeed, in part because now that everything is digital, no, it's almost impossible. Next time we will start with Amendment 2. That finishes our discussion, at least for now, of the First Amendment. Next time we'll go through the rest of the amendments, and we will start with the controversial Second Amendment, whose language is on the slide in front of you. Have a good day.
I really want to